Why is UCC turned down? Author M. Akbar, Part 3, Decline into Retrogression. Articles 36 to 51 of Part 4 of the Constitution of India present the Directive Principles. These are directives to be followed by the government in administration and legislation. Although the 44th article does express that the country should strive for a uniform civil code, anyone with basic knowledge of the Constitution would understand that no directives are more crucial than fundamental rights. The freedom to practice one's religion is a fundamental right given to every Indian citizen. It is a right that even the Parliament cannot deny anyone. The directives are what the framers of the Constitution intended for the state to implement in the country. However, we must acknowledge that none of the past governing bodies since 7 decades of our independence has been able to implement any of these directives completely. It is interesting to note that in the speech delivered by then Prime Minister Jawaharlal Nehru while introducing the 4th Constitution in the Parliament, he said that if there is a conflict between the fundamental rights and the directive principles, the fundamental rights shall take precedence. All these show that those who claim to try and implement any of the directives while denying fundamental rights are challenging the integrity of the Constitution. When the Indian Constitution came into existence, the Sharia Application Act of 1937 for Muslims, the Indian Christian Marriage Act of 1872 for Christians, and the Parsi Marriage and Divorce Act of 1936 for Parsis existed as personal laws. However, there were no general personal laws for the Hindu majority. Laws among Hindus varied according to caste, tribal, and regional differences. So when the framers of the Constitution wrote in the guidelines that the state should strive for a unified civil code, they may have suggested that it may be needed to bring them under a unified law too. To imply that the framers of our Constitution encouraged the state to bring about one personal law for all religious people while undermining fundamental rights would be an unreasonable claim. That must be why the phrase Uniform Civil Code was used in the guidelines rather than Union Civil Code. With the enactment of the Special Marriage Act of 1954 and the Hindu Marriage Act of 1955, there was a uniform civil law that could be adopted by all Indian citizens, which meant that there was no longer any need to strive for the Uniform Civil Code mentioned in the directives. Depriving a citizen of their fundamental right to religion is against our Constitution. Such a move is impossible unless the very foundations of the Constitution are changed. When asked if it was time to make efforts for a uniform civil code, the 21st Law Commission, chaired by Dr. Justice Balbir Singh Chauhan, replied that now it is neither necessary nor desirable. His reply may have been a pointer to his conviction that such a law can never be enacted in a way that would protect the pluralism of India and the fundamental rights of its citizens. This has been unequivocally stated in the consultation paper Reforms of Family Law, issued by the Law Commission in August 2018, after examining the issue in detail and seeking public input. The Law Commission said, "This commission has therefore dealt with discriminatory laws rather than providing a uniform civil code, which is neither necessary nor desirable at this stage." Most countries are now moving towards recognition of difference, and the mere existence of difference does not imply discrimination, but is indicative of a robust democracy. The Law Commission suggests that while the world is moving more and more towards pluralism, India is going backward by implementing a single civil code. In other words, the Uniform Civil Code will lead India to regression, not progression.